The major test with this is the definition of what this building can be used for. The important definition you need to understand is that it's incidental to the enjoyment of the dwelling house. So if you build an outbuilding within the curtilage of your dwelling house, it needs to be incidental to the enjoyment of the dwelling house. What it's trying to say is that you cannot turn it into a flat. So you can build a swimming pool, you can keep bees, you can keep chicken, you can do whatever you want. It can be a home office. You know, the point is that it's an extension of that home for the purposes of the people living in it. You can't use the outbuilding to then create a self-contained flat and then rent it out or sell it or whatever. If you want to learn more about the planning process and how you can unlock value out of any property, click the link below to learn more. I've done a load of videos already on permitted development rights, the benefits of them, the amount that you can do with them, but this video is going to touch on one part. It's a topic that's searched a lot, I get a lot of questions about, so this is going to be one of a series of videos that I'll do on each part of permitted development rights. And if there's certain class of permitted development rights that you want me to do a video on, then put it in the comments below and I'll make sure to do a video on that. So today we're going to be talking about outbuildings. So there's a form of permitted development that you can build an outbuilding within the curtilage of your dwelling house. There are a few conditions around what you can and can't do. So this video is going to kind of run through that so that you are armed with that if you're ever considering doing an outbuilding on your property. Maybe you think it's going to add value to a property that you want to sell, or maybe you just want to build it for yourself. There's a few things you need to know before going into it. As a reminder, permitted development rights are a form of development that you have a right to exercise without the need for planning permission. That's why they're called permitted development rights. There's a document called the General Permitted Development Order, and in there it lists massive amount of development that you can do without the need for planning permission. There are lots of different parts within it, and there are conditions within each one that you need to meet. Some you can just do without planning permission, some require something that's called prior approval, which is kind of a pared down planning application where you don't need to submit so much detail, you just need to submit a few things in order for the council to make an assessment. The big benefit with permitted development rights though is to do with residential. That's where the real benefit lies with them. It's not so beneficial if you have different types of properties, but with residential there are huge amounts of opportunities you have right now, and that's what this video is going to touch upon. The big picture is that right now the country is really struggling for housing, and the government is expanding permitted development rights in order to get the country to build again, in order to deliver housing. So for the first time ever, permitted development rights now allow you to build new flats under PD. That's never been done before. Normally, as a rule of thumb, if you're creating any new units, that's when a planning application is needed, and that's when you get into negotiations with the council. That's when you have to make contributions. That's when you get into legal agreements. That's when you have a consultation exercise. That's when you have real chance of refusal. That's when you have inconsistency of decision. That's when you have 6, 7, 8, 9, 10, 11, 12 months of waiting for a decision without ever actually knowing, never speaking to a case officer. So you kind of get an idea as to what I'm getting at with the benefits of permitted development rights. If you use permitted development rights, then you don't need to go through the planning application process, which is this unnecessarily long, drawn out, complicated process with no guarantee really as to the outcome. So with all that said, this video is about outbuildings, which is only one part of the General Permitted Development Order that you could use to add a huge amount of value to your property. The first thing to know before you get all excited about going ahead and building an outbuilding is Article 4 directions. Article 4 directions is a thrown about term by people that don't fully understand what it means, and it's really important because a lot of people get scared away from certain developments that they think, oh, I'm in an Article 4 area, or there's an Article 4 direction affecting my site that prevents you from doing it. But the truth about it is that Article 4 directions only prevent certain types of permitted development rights. So in order to implement an Article 4 direction, the local council has to apply to central government, and they've got to provide all this justification as to why they want to implement an Article 4 direction. So maybe, for instance, if it's rear extensions and there's an issue in a certain area and that creates major issues, the council has to make a full justification to central government in order for that to go through. The big one that's going on right now is Class MA permitted development, which is the change of use from commercial to residential. Previously, councils did a blanket Article 4 direction across the whole borough, which wiped out the possibility to use that permitted development right. Now that test is a lot more onerous on councils. They're not allowed to do blanket proposals, and they have to provide real detailed justification as to why they need to remove that. So an Article 4 direction lists exactly what permitted development right it is removing. So when you find the Article 4 direction, if you do your searches and you find out that an Article 4 direction is in place, don't assume that you cannot benefit from permitted development rights on that site. It is just that you can't benefit from one type of permitted development. Well, it could be more types of permitted development, but it will list which ones. So today we're talking about Class E within Part 1 of the permitted development order. It's just one of those things within planning. It's made unnecessarily complex, but there are parts within the permitted development order that divide up essentially what types of PD that you can do. And today we're talking about Part 1, Class E, which is buildings within the curtilage of a dwelling house. So we've talked about what PD is, we've talked about what Article 4 directions are. The major test with this is the definition of what this building can be used for. At the bottom of the class, there's a definition of what this class is. The important definition you need to understand is that it's incidental to the enjoyment of the dwelling house. So if you build an outbuilding within the curtilage of your dwelling house, it needs to be incidental to the enjoyment of the dwelling house, which basically means that what it's trying to say is that you cannot turn it into a flat. So you can build a swimming pool, you can keep bees, you can keep chicken, you can do whatever you want. It can be a home office. You know, the point is that it's an extension of that home for the purposes of the people living in it. You can't use the outbuilding to then create a self-contained flat and then rent it out or sell it or whatever. So that's what it's trying to prevent. It's just extra floor space that you can use for the enjoyment of your dwelling house. And obviously right now it's a huge thing. Everyone's working from home at the moment, so this class is going to be used more and more and more as work practices change and offices within major cities close down and more people work from home. So now we're going to run through each different bit of criteria that you need to know. This will be quite quick. The important stuff is I've touched on about what are permitted development rights, what is an Article 4 direction, finding out the detail of that, and then if you are going to use this class, making sure that it's incidental to the enjoyment of the dwelling house and that you're not going to turn it into a flat. So the first thing is it cannot be more than 50% of the curtilage of the dwelling house, excluding the area of the original house. So if you have a detached house like that, and then you've got this big area around it, you can build, it can't be any bigger than 50% of the total curtilage minus the building itself, so that you work out the area that you have to work with there. So that's the thing, just exclude the original dwelling house when you're thinking about using this class. Second one is that it cannot be forward of the front elevation. So we've talked about the whole area you can use, but you can't go forward of the main house. So you can't go and put an office in between the front elevation and your front wall of your property, basically. That's all it's saying. It can only be single story. So there are a few height restrictions with this. So if you're doing a dual pitched roof, the pitch of that can't be any higher than 4 meters. If you are building within 2 meters of the boundary of your curtilage, it cannot be higher than 2.5 meters. Essentially what that is doing is making sure that you're not impacting on the enjoyment of someone else's garden next door. So if you make sure that it's more than 2.5 meters away from the boundary, that way you can build up to 4 meters if you've got a dual pitched roof. And also if you're not doing a pitched roof, you can't go any higher than 3 meters. So if you're going to do a flat box, 3 meters. Just make sure you stay away at least 2 meters away from the side boundary. The eaves of the building can't be any higher than 2.5 meters. So 4 meters high, the eaves can't be any higher than 2.5 meters. You cannot use this class if you are a listed building. It doesn't include the construction of a veranda, balcony or raised platform, and it explicitly says you cannot use this to create a new dwelling. I've already touched on that, but that's a really important point. Don't put plans in to put a kitchen and a shower and then rent it out as a flat, because you'll get called up on it and it could be that you could get the whole thing pulled down. It cannot exceed 3,500 litres. So with all these restrictions that I've spoken about in terms of 50% of the total curtilage, the height restrictions, 3,500 litres, it can't be any bigger than. Whichever is the lowest is what you've got to work with. If you're in an AONB, the Broads, National Park or World Heritage Site, you're very, very limited about what you can do with this. And if you're in a conservation area, you cannot use it to put it in between the side elevation of the building and the side boundary. So it has to be essentially what that's saying. If you add up all the other restrictions, it can't be to the front of the building, and if you're in a conservation area, it can't be to the side. It's basically saying put it to the back so that it doesn't affect the character of the conservation area. And then lastly, I've already touched on, it's got to be incidental to the enjoyment of the dwelling house. So just use it for extra floor space if you want it to be, but the point is it's an extension of the dwelling house. You cannot use it to turn it into an extra flat. The reason I labour this point so much is because I've been involved in an appeal with this, where someone tried to use this part of the PD rights to essentially circumvent the system to make it look as though they're not going to use it as a flat, but in actual fact they were. So in the instance that I was referring to, the back of the property faced onto a mews, so they wanted to put a outbuilding which could have its own access, and it had its own plumbing and things like that. It looked like they were going to use that as a flat. It was quite clear that they were going to, but they were using PD rights to kind of use that as a benefit to them. But it went through an appeal, so that's why I labour the point on the definition, because it's really important. And that in the appeal that I was involved in, that's what they focused on. We were laboured over the definition of that, and it was quite clear that that was the reason it failed. So I hope you found that useful. Like I say, permitted development rights, huge opportunity right now. I hope this one sticks around for a long time, because it's really beneficial for all of those people like myself that work from home a lot. There are so many permitted development rights right now. I've done a video on this one now, Class E. There's one I've done on Class MA. But if there's any other part of the PD rights that you want me to go over, happy to do a video on that. Just leave it in the comments below and I'll do that. But I'll see you on the next video.